So, we start. Good afternoon. Welcome to this hearing on jurisdiction and liability in exit case ARB 1414, EuroGas Inc. and Belmont Resources Inc. Versus the Slovak Republic. As you can see, the hearing is video recorded so that it may be made public at some later point on the ICSID website. And of course, there's also a transcript by Mr. Gowan. You know the tribunal, Professor Emmanuel Gaillard, Professor Brigitte Stern, myself. Ms. Lindsay Gastrell is the secretary to the arbitral tribunal, and Ms. Céline Lachman is the assistant to the tribunal. We also have the presence of our trainee, Mr. Bertrand Lévesque, by special permission from the parties whom we thank. Maybe claimants want to introduce their teams.
Good morning, good afternoon, Mr. President, Professor Stern, Professor Gaillard. On my left, my colleague from the firm Doransky ARB, Emmanuel Foy. Next to him, President and CEO of my client, Belmont, Mr. EuroGas. Then we have two members of my team in the middle, Ms. Mons, Ms. Denk, but also a third one.
Maybe you can raise your hand when your
Yes, please
name
raise
is
your
pronounced.
hand. Ms. Mons, Ms. Denk, and Ms. Morara. We have our mining expert, Mr. Hill, and I take this opportunity also to introduce Mr. Lepage from La Française. Ms. Burton will present Belmont's team, EuroGas's team.
Yes, Ms. Bell.
Thank you and good afternoon, members of the tribunal. My name is Mona. Thank you. My name is Mona Burton. I am representing EuroGas along with my colleague Maureen Witt, who is to my left. The president of EuroGas, who is present, is Wolfgang Robel. Wolfgang, will you raise your hand? We also have present the corporate attorney for EuroGas, Mr. Michael Coombs. And the other members of our team are our legal expert witnesses, Mr. David Lita and Mr. Brad Merrill.
Thank you. So today's program is the opening statements, but first we hear Mr. Anway presenting his team.
Thank you, Mr. Chairman and distinguished members of the tribunal. To my right, David Alexander from Square Patent Boggs. To his right, Eva Sibukova of Square Patent Boggs in Bratislava. To her right, Maria Polikova from our Prague office. To her right, Rustislav Pekash, a partner in our Prague office. Then we have Raul Mignon, who is a partner in our Miami office. We have Andrea Holikova, who heads the Ministry of Finance's dispute resolution team. To her right, we have Tomáš Juka, who's also from the Slovak Ministry of Finance. Then Radovan Hronský from the Slovak Ministry of Finance. I think the next person to your right, Radovan, is Miss Annette Jarvis, who is our Utah law expert. To her right is Mr. Greg Sparks, our mining expert. To his right, Katarina, and you'll have to help me with your last name, Katarina.
Hlasek Dosadelova.
From PwC in Prague. And to her right, you see Sershar Qureshi, who is from PwC in Prague as well. Thank you.
Yes, opening statements, which will last the whole afternoon, I think, until at least 8 o'clock. Unless you're shorter than you had foreseen. But before that, there are a few matters. First, as has been said, we have the presence of Mr. Michael Coombs, EuroGas's corporate lawyer, who has submitted an undertaking to abide by the tribunal's orders and rules. We have Mr. Lepage, who has just submitted, I understand, a similar undertaking. Then we have received during the previous days, which have been very busy for everybody, a certain number of documents. R 2091 and R 2092. We have received yesterday or this morning, yesterday I think, C3662 C370, and on these documents Slovakia has the right to comment at the appropriate time. Then we had a request from EuroGas to accept new versions of CL223 and CL224. Is there an objection to these new versions?
With respect to the legal authorities, which I understand are just completed exhibits or corrected exhibits, we have no objection. As to the factual exhibits, we will come to those in due course.
You mean the Keller documents?
That's correct.
That's right. Well, we've read the letters from both parties. You know that a certain decision had been made because we thought that after some time there would be no objection, but there was one afterwards, so we decided to reopen the matter, and then we discussed it just now and decided not to admit these documents. Now, another point, we'd like to know where we are exactly as to the number and the identity of the witnesses and experts who are going to be cross-examined, or even if they're not cross-examined, if there will be direct examination. So I'll tell you what I have understood, but there's been a very recent change, so I'm not sure I'm right. I'll tell you. First, respondents' witnesses to be cross-examined by claimants. Mr. Peter Kukelchik will be examined, and Mr. Peter Courage, and no other witness. That's right, okay. Now, they're experts. Ms. Janvis, Samuel Gardiner, John Anderson, Gregory Sparks. That's right? No other. On the other side, claimants, witnesses to be cross-examined by respondents. Mr. Wojciech Agiagos.
Correct.
Mr. Wolfgang Raubal.
Correct.
And Mr. Andrzej Rozlosnik.
Correct.
Correct. And as experts, only Mr. Hill.
That's correct. We have indicated that we do not see the need to have the Utah law experts, being legal experts, testify before the tribunal. If the tribunal wishes to ask them questions, then we do reserve the right to conduct a cross-examination. We've also indicated that the KPMG expert offered by the claimants is someone that we do not intend to cross-examine again unless the tribunal were to call them.
Are there witnesses or experts who would be called for direct examination, although they're not called for cross-examination?
I don't believe so, Mr. President, and my request would be, my legal experts have flown here from Utah. I understand that the respondents do not intend to cross-examine them. I would request to be informed if the tribunal wants to cross-examine them, because if not, I might want to let them go home.
Okay. We will tell you after the first break. Okay. So, before the opening statements, are there any other matters?
Yes, Mr. President. There are two matters. We understand that the tribunal has now excluded the two documents that it had admitted based on the arguments of respondent, to which we did not respond. Now, we don't want to create an issue with that. We are, as far as Belmont is concerned, fine with the exclusion of the affidavit regarding the email from Scheller to Keller, dated April 11th, 2005, we asked the tribunal to reconsider its reconsideration for procedural reasons, simply because we didn't have the opportunity to respond to the new arguments, but more importantly for two reasons. One is that that email was expressly identified in our reply memorial at paragraph 464. We only had a clearance from the source, Mr. Keller, so that we submit it when we submitted to the tribunal, when we asked leave to submit it. The second reason, independently of that, is that that document falls expressly within the document production order that you ordered. So there's an ongoing obligation of respondent to submit that. So for that independent reason, that document should be admitted. And finally, there is no prejudice, obviously, because we identified the document. It's their document. So we ask you to reconsider it and kindly rule on this issue before we take the floor, because we wish to rely on that document. The second issue we want to raise is the status of legal authorities. What do we do with legal authorities? We want to rely on two legal authorities that are not on the record. And please also think in advance, what do we do in rebuttal during the course of the process if there are new legal authorities that become relevant and need to be raised either by respondent or us. But for the time being, we have two legal authorities on which we want to rely on in our opening statement. One is an agreement between Slovak Republic, BIT, and Iran. It's dated January 19th, 2016, so it's after the submissions. And obviously, Slovak Republic, it's legal authority, but it's a document of the Slovak Republic. It's a signatory to that agreement. And the second document is the dissenting opinion of Professor Stern in the Occidental decision was submitted as CL0267. It's heavily relied on by respondent. The Occidental decision itself relies heavily on the Professor Stern's opinion. We just want to have that admitted on the record because we want to address that during the opening.
We can certainly talk with opposing counsel about his request to introduce those authorities at a break. It's not something we've been approached with before. I certainly don't see any problem with Professor Stern's dissenting opinion, but it's something we'd like to discuss with our client with respect to the other matters. With respect to the first comment that my colleague raised, as I understand it, there is not a reconsideration request for Mr. Keller's new affidavit, there being two, the other one being 2.5 years old and the same in substance. The request is only for the email. The suggestion that the Slovak Republic had an obligation to produce it presumes that it was within the possession, control, or custody of the Slovak Republic, which it was not. The document's over a decade old. There was no legal requirement for the government to retain those documents. We were never in possession or control of it when the document production order came down. Candidly, that was the first time we had ever read anything about such an email, and we saw it in the claimant's reply, but they did not exhibit the document. And we still have been provided no reason as to why they didn't exhibit it. We think it is simply unfair to be springing on a party days before the hearing that has already been delayed 9 months because of this party, brand new documents.
Thank you. We'll decide before you take the floor on this issue. We'll have first phase on jurisdiction, respondent first, then claimants, then a second phase on liability, claimants first, respondent second. I think that's the...
President, on this counter proposal, we didn't have a chance to comment as well. Before you took the decision, we're fine with it. Respondent takes the floor first and addresses jurisdiction. Then you want us to address jurisdiction and liability, and respondent takes the floor again on merits. We're fine with that. Simply for purposes of form and substance, we want to start with merits and jurisdiction, and then respondent takes the floor and addresses merits again. It doesn't change anything. It's just safe that when we take the floor, instead of going addressing jurisdiction and merits, we'll do merits and jurisdiction, because it just flows better, and then respondent takes the floor.
This was, as I understand it, if I'm understanding that correctly, the offer that, not the offer, the suggestion you had made initially was to do your closing with merits first and then jurisdiction, so you would have the last word.
Sorry, this is for just the opening. I'm talking about the opening. I said doesn't
You're
change.
proposing for the opening what you had proposed for the closing?
No.
Okay, maybe I didn't understand.
The new ground rule, as I understand, is that respondent starts with jurisdictional objections, correct?
Correct.
Then we were to take the floor to address jurisdiction and merits before you would take the floor back to address merits.
Correct.
We're fine with the first step. You start with jurisdictional objections. We will just say merits jurisdiction instead of jurisdiction merits, and you take the
and then
floor.
we would end
Yes, but
with-
simply it
I
flows
see.
better. That's it. I think
It's
that's
just
not.
a difference. What you suggest is differing from what the tribunal had accepted, is only in your part you.
Yes, in our part,
doing
just
that.
because of organizational purposes, and also it flows better because the jurisdictional objection is tied to the merits.
We have no objection. That's more a problem for us to better understand, but I suppose you know better than us what is easier to understand. So we accept that. The breaks. There may be either 2 breaks or 3. My suggestion would be 3. One after respondent on jurisdiction. Well, no, stemming from what Mr. Garavi has just said, then would be 1 after the respondent on jurisdiction. Then, if you want to have a break in the middle, it's possible after merits. And then we'll have respondent, and that's all. In fact, 2 breaks. Good. So we're all ready to listen to respondent on jurisdiction.
Before you begin, can I ask you to pause for a couple of minutes? I can see there are a few screens that have not all the text on. I just need to reconnect.
I have none.
Yours, for example. Yeah.
Why don't you pass out the PowerPoints? Can you ask Marie to pass out the PowerPoints or have someone distribute them? You mind if I have the next one, of course, thanks.
This is going to take longer than just a couple of minutes. I need to restart the computers. So would you like to start now until the break with just some of them working? Or take that time for you to
Can you do the
restart?
court reporting without the live note?
Yeah, sure. Yeah.
I don't need the live note. I don't know if the other side requires it, but I'm happy to start now without the live note, if that helps.
That's it. Thank you. Don't worry about it.
Okay.
Mr. Hanoi.
Thank you, Mr. Chairman. So you see we have a presentation today that will be aided with a PowerPoint, which you should have received now. And if we move to the next slide, Mr. Chairman and distinguished members of the tribunal, our presentation today will be divided into 3 sections. First, I'll make a preliminary statement with regard to the claimant's conduct in this arbitration as it pertains to the tribunal's jurisdiction since our last hearing here in Paris almost a year and a half ago. Next, I'll review in some detail the 2 reasons why the tribunal does not have jurisdiction over EuroGas 2. First, that EuroGas 2 never owned the alleged investment, and second, that the Slovak Republic properly denied EuroGas 2 the benefits of the U.S.-Slovak BIT. Following that, I'll review the 2 reasons why the tribunal has no jurisdiction over Belmont. First, that Belmont sold the investment in 2001 before the alleged violations. And second, the Canada-Slovak BIT only started to apply in March 2009, which were after the violations. So on to the preliminary statement. I'd like to begin by asking the tribunal to step back and reflect on what has occurred as it relates to your jurisdiction over the course of the last year and a half. The tribunal will recall that in their request for arbitration, which you see up on the slide, the claimants misrepresented to you who they are. They actually misrepresented to you their own identity. One of the claimants, EuroGas Inc., told you that it was a Utah company incorporated by Mr. Robal in 1985, and which in fact did own the alleged investment at one point in time. In reality, the claimant was a different entity, not the one disclosed to you. It was a Utah company that Mr. Robal created 20 years later, in 2005, with the same name, the same address, the same officers and directors. And because it was a 2005 entity and was created after the Talc mine interest was reassigned, the 2005 entity could have never owned the alleged investment. In other words, the tribunal's jurisdiction depended upon that misrepresentation. Now, the Slovak Republic, through its own research, discovered the truth. We discovered the existence of the 2 companies going by the same name, EuroGas Inc. We discovered that the 1985 company had been dissolved under Utah law in 2001 and therefore lost the ability to do anything except wind up its business activities. We discovered that it was put into bankruptcy in 2004, and we discovered that it was liquidated, its assets, in that bankruptcy in 2007. We discovered that the 2005 company was created while the 1985 company was in bankruptcy, and created in secret, without telling the bankruptcy court, without telling the bankruptcy trustee, without telling the investing public. So to the outside world, with the same name, the same address, the same officers and directors, the 2005 company looked the same as the 1985 company, intentionally. And we will show that Mr. Robal created this new company for a fraudulent purpose, to later exercise control over assets, including this ICSID claim that he never disclosed to the bankruptcy court. Now, as you know, we call the 1985 company EuroGas 1 and the 2005 company EuroGas 2. Having been caught in that misrepresentation, the claimants were forced to admit that they were indeed a different entity than what they told you. Members of the tribunal, it is no exaggeration to say that had we not caught EuroGas 2 misrepresenting its identity to you, something that we assume claimants' counsel had not been aware of, this entire arbitration would have proceeded on a fraud. We ask you to bear these facts in mind when considering our application for a costs award. What else has changed concerning your jurisdiction since our last hearing? Well, EuroGas's jurisdictional case, no less than 4 times. After coming clean with the tribunal about who the real claimant is, EuroGas 2 had to change its explanation for how you even have jurisdiction to hear the claims. They have literally changed their jurisdictional story with every pleading they've made to you, all 7 of them. The complexity of the transactions involved in claimants' ever-evolving jurisdictional case has made your and our assessment of their jurisdictional theories, as you will soon see, exceedingly difficult. What else happened concerning your jurisdiction since our last hearing? The Utah bankruptcy was reopened. And we have learned that Mr. Robal was again not truthful with you when he told you who caused its reopening. We were first informed about the reopening when we read claimant's reply brief. That was in September of 2015. Had never heard anything about it before then. So we were even more surprised when they blamed us for it in that pleading. They stated that a creditor of the bankruptcy estate, called Texas EuroGas, was asking the U.S. trustee to reopen the bankruptcy. And here's where they blamed us for it. They said, respondent to the Slovak Republic has managed directly or indirectly to induce an alleged Texas creditor of EuroGas, Inc., a company that was incorporated in 1985, to file a motion to reopen the company's bankruptcy case in Utah. Now, members of the tribunal, at the time, we told you that we did no such thing, but we continued to hear this accusation for the next year, as recently as our pre-hearing call last Monday. And, lest there be any doubt, you can see in the next 2 slides letters where they accused us of causing this reopening because we had leaked the expert report of Annette Jarvis. Recall, members of the tribunal, she is our Utah law expert. And although pleadings in this case are public, expert reports are not on the ICSID website. We were accused of leaking that report to Texas EuroGas, and Texas EuroGas then attached that report in its request to the U.S. trustee to reopen the bankruptcy. And in another letter, they effectively made the same allegation, the diffusion of the same information that caused the Texas reopening. Members of the tribunal, in a document filed into evidence in the Utah Bankruptcy Court last Thursday that we had no knowledge of before, we have learned that, in fact, after all those allegations against us, it was Mr. Robal himself who leaked Ms. Jarvis's report to Texas EuroGas. And here's the email where he did so. From Wolfgang Robal to David Sachs, you can see right next to David Sachs' name, it says Texas EuroGas, that's the creditor. David, I come to plan to see you and Mike McKenzie. In the second paragraph, I am sending you ahead of our planned meeting the big legal stumbling block. The big legal stumbling block, which our lawyers are fighting in the arbitration. And if you look at that document, we don't have it up on the slide, but it attaches Ms. Jarvis's report in full. Now think about what that means. Despite Mr. Robal personally leaking to Ms. Jarvis's report to Texas EuroGas, he thought it was appropriate to tell you that we had done it. And he let his lawyers continue making those false allegations against us for the last year. What else happened concerning your jurisdiction since the last hearing? Well, the claimants refused to show up to the January hearing. In another document filed with the Utah Bankruptcy Court last Thursday, so these documents are all in the public domain, counsel for claimants in this arbitration in October 2015, and you can see it up on your screen, had concluded that based on the jurisdictional problems before this tribunal, the, and I quote, best case scenario, the best case scenario was for claimants to postpone the January hearing. We know now that that was back in October 2015. The tribunal will recall, however, that claimants waited until just before the January hearing to ask for postponement, and its justification was that the Utah bankruptcy reopening, which we now know Mr. Robal caused when he leaked Ms. Jarvis's report, was pending, and EuroGas 2 wanted, as we now know, to try to solve its jurisdictional problem in the Utah Bankruptcy Court before it had to show up before you for the merits hearing. Now, you members of the tribunal denied that request and ordered that that arbitration hearing proceed. Unhappy with your ruling, the claimants just refused to show up. They said they needed new counsel because of a new unidentified conflict of interest. We invited them to identify what new conflict of interest could have arisen that did not already exist since the beginning of this case, but they declined to do so. Nevertheless, the claimants put the tribunal in an impossible position when Mr. Robal withdrew his consent from Mr. Garavi to represent him at that January hearing. In so doing, he effectively handcuffed the tribunal and blew up the January hearing. 6 months later, Mr. Robal told the tribunal that he had retained Ms. Burton, a lawyer with whom he has been working on this matter since all the way back in October 2015, and whose document I just showed you, where it said the best case scenario was for postponement of the hearing. So EuroGas 2 forced the tribunal to give it what the tribunal previously denied it, its best case scenario. Postponement of the January hearing so EuroGas could try to solve its jurisdictional problem before the Utah Bankruptcy Court. And we know they have tried to do just that. As we informed the tribunal, EuroGas 2 has made an offer, struck a preliminary agreement with the trustee to purchase whatever interest the bankruptcy estate has in the talc deposit, in exchange for which EuroGas 2 will pay $425,000 and cause Texas EuroGas to withdraw an alleged $113 million claim against the estate. Now, why would Texas EuroGas agree to withdraw its claim against the estate? We have reason to believe that it is because Mr. Rolba has reached a side deal with Texas EuroGas and will give it a portion of whatever award he receives in this arbitration. Members of the tribunal, I ask you a simple question. Why would EuroGas 2 pay almost $500,000 and other consideration for something that it has told you it already owns, this ICSID claim? The answer is that Texas EuroGas knows it does not own the claim, the bankruptcy estate does. And EuroGas's own counsel in this arbitration admitted this in yet another document filed before the Utah Bankruptcy Court last Thursday. This email is from EuroGas's counsel in this arbitration, and it states, quote, "The reopening of the case will necessarily carry with it the conclusion that the asset was not abandoned and that EuroGas 1 still owns the claim and EuroGas 2, the claimant in this arbitration, does not." The final thing that occurred regarding your jurisdiction since our last hearing was a series of events last week. Recall that the claimants were instructed by you, members of the tribunal, on that call we had in January 2016, where they refused to show up at the hearing, that they could not use the delay that they had caused to try to improve their position in this arbitration by introducing new exhibits or new witness statements. Yet last week, days before a hearing, we saw a flurry of requests seeking to do precisely that. Claimants sought to introduce documents that they say, allegedly, proves when EuroGas 2 made its alleged investment and that it even made an investment, days before the hearing. This arbitration has been going on now for almost 2 years, yet at no time have claimants ever tried to put these documents into the record. Now, the tribunal has permitted those documents into the record, and I will comment on them shortly. But we have been given no reason why those documents were not put in earlier when we would have had an opportunity to fully analyze them and address them in our memorials. Instead of offering an explanation, claimants actually blamed the Slovak Republic because we didn't put in their evidence for them. These are not serious positions. Also last week, claimants tried to haul before you, with no notice, one of the highest-ranking government officials in the nation, the Minister of Finance himself, even though in 2 years of arbitration they have never notified the Slovak Republic of its intention to do so, and even though the Minister of Finance, even more importantly, who only took office in 2012, had absolutely nothing to do with the facts concerning the talc deposit. It was a plain attempt at harassment, unconnected to the truth-finding process. Also last week, we saw an unprecedented request for provisional measures, seeking to have you remove us from this Utah bankruptcy proceeding so that claimants could proceed unopposed to silence us. Now, as you know, the Utah Bankruptcy Court held a hearing on EuroGas 2's proposed deal with the trustee last Thursday, and they pushed very hard for the judge to approve their deal last Thursday, because recall, they have wanted that deal approved before they show up to this hearing. It's the reason for the initial postponement. It was the reason why they pushed so hard last week. Emphasizing the imminence of this hearing, EuroGas 2 pushed very hard, but the judge did not approve the deal at the conclusion of the hearing, and instead he granted our request to have a further hearing on 26 September. And therefore, the proposed deal, which you'll hear about today, has no legal effect. And it may not ever, and will not ever, unless and until it is approved and sustained by judicial review. Last week, as we've already talked about this morning, claimants tried to introduce an affidavit, allegedly of a witness. They say it was before a U.S. notary public who witnessed it, and in fact was done in Germany, just like the original affidavit, which I'll come to, making inflammatory accusations. And we are supposed to believe that it is just a coincidence that this affidavit was signed one business day before this hearing. Just a coincidence. These documents, if admitted, and I understand they will not be, and that there has not been a motion to reconsider that decision, would violate numerous provisions of this tribunal's procedural orders and would violate the Slovak Republic's due process rights, as we explained in our letter last Friday. Now, I do want to be clear. The claimant stated they could not introduce that affidavit into the record earlier because it was executed 2 days before they sought its entry into evidence, which was on 7 September 2016. In fact, that same individual, Mr. Keller, authored an affidavit before a German notary public 2.5 years ago, and it was the same affidavit. And claimants were well aware of it because at the time, Mr. Rollball himself immediately shared the affidavit with the Slovak press. And here's the press article proving it. This was in the media. So Mr. Rollball and EuroGas 2 had the same affidavit for 2.5 years, yet never once in more than 2 years of proceedings have claimants raised these allegations or introduced evidence in support of them before the tribunal. Instead, they waited and waited. And literally 1 day before the hearing, they have a new affidavit signed saying the same thing as the earlier affidavit, and they spring it on us in the tribunal as if it's something new. How convenient. In short, claimants are misrepresenting to the tribunal that this is new information to them when they've actually had it and publicly circulated it for 2.5 years. This flurry of activity we saw last week shows that claimants know their case, as put to you, has utterly failed. New documents, new witness statements, new provisional measures, all a week before a hearing that they've already delayed 9 months. We would ask you to bear all of these facts in mind when you consider our application for a costs award. Now, against that backdrop, I turn now to the 2 reasons why the tribunal has no jurisdiction over EuroGas 2. The first one, of course, is that EuroGas 2 does not own and has never owned the alleged investment. It is, or it should be, common ground that the claimants bear the burden to prove that EuroGas 2 qualifies as a protected investor with a qualifying investment at the time of the alleged breaches of the U.S.-Slovak BIT. And I emphasize the last point, at the time of the alleged breaches of the U.S.-Slovak BIT. Now, despite bearing the burden to prove the facts necessary for this tribunal's jurisdiction, claimants have offered no less than 4 different stories for how EuroGas 2 owns the alleged investment. We showed 3 of them to you in a table in our rejoinder under paragraph 4, which you now see up on the slide. As you know, their first story in their request for arbitration was that EuroGas 1 was the claimant and owned the investment through its Austrian subsidiary, EuroGas GmbH. We showed you that was a misrepresentation. Claimants now admit that. They scrapped that theory and came up with a second one. The second theory, which appeared in the memorial, was that EuroGas 2, not EuroGas 1, was the claimant and had, quote, assumed all of the assets of EuroGas 1 through what they called a Type F reorganization in 2008, which they say they effected through a document called a joint resolution that was claimed to be executed by directors of EuroGas 1 and EuroGas 2. Well, we demonstrated that can't be correct either, because a Type F restructuring is so named because it falls under a subsection F in the Internal Revenue Code, the IRS. It's a tax statute in the United States. And as a tax statute, it can't merge corporate entities. So we pointed this out to the claimants, and in fact, they came back and admitted we were right about that too. They say in their reply, you had up the correct one. U.S. Internal Revenue Code could not in and of itself serve to realize the merger. And in fact, their experts, Mr. Lita and Mr. Merrill, go further and say, Ms. Jarvis, our expert, is correct that this tax law, commonly referred to authorizing a Class F reorganization, does not authorize a merger under state law. So they go back to the drawing board again, and they come up with a third story. The third story, articulated now in the reply, is that EuroGas 1 and EuroGas 2 merged not through a Type F reorganization, but rather through something they call de facto merger, common law de facto merger. And they also raise a fourth new theory, disclosed for the first time ever, and these relate, Mr. Chairman and members of the tribunal, to the ruling you made last week, granting the entry of 5 new documents. This new story, they tell us, in their 7th submission in this case, and the last one before this hearing, is that EuroGas 1 in fact sold its investment to, and its investment in EuroGas GmbH, its subsidiary, and thus the talk interest, to a UK company called Macallan in 2007. And then EuroGas 2 purchased Macallan at some unspecified time in the future. That's a remarkable admission. That's the investment. They don't even tell you when they made it. And then Macallan transferred EuroGas GmbH to EuroGas AG, a Swiss entity, in 2012. These are the 2 paragraphs in the reply where claimants take this position. This is the totality of the information we were provided before last week about this Macallan transaction. Okay, now if we take a step back, we might ask ourselves, how do all these theories and facts, alleged facts, fit together? How can we make sense of them? How should we think about them? What kind of analytic framework do we put them in to understand how this all will work? As you've seen from our rejoinder, these complicated and ever-evolving jurisdictional quote-unquote facts have made a complete and total mess of claimant's jurisdictional case. I'm going to take you through that complexity today in a way that I hope will be digestible and as simply as I can. But before I do that, I want to tell you, you can avoid all of it. You can avoid the complexity. There is a threshold issue where if you decide it a particular way, all of this gets avoided. If the tribunal simply concludes that EuroGas did not emerge from the bankruptcy with the alleged investment, if you make that conclusion that the bankruptcy estate did not abandon the asset and still owns it, none of these facts matter. Because if the bankruptcy estate owns the investment, then neither Macallan nor EuroGas 2 nor EuroGas AG could have later come into possession of it, whether by merger, acquisition, sale, or otherwise. So, what I'm going to turn to next is that threshold issue. I'm going to avoid the complexity for now. We'll go through the threshold issue, and only if you decide against us on the threshold issue would all the complexity then come into play. First issue then, whether EuroGas 1 emerged from the bankruptcy with the alleged investment. If the tribunal concludes it did not emerge with the investment, it can stop there. It has no jurisdiction over EuroGas 2. The entire problem in the bankruptcy was created because of one fact. The bankruptcy judge in that case issued an order for persons responsible for the debtor was EuroGas 1, to file schedules of assets and liabilities of the company. That is a statutory requirement. It was an order from the judge, and he named 3 individuals that was under an obligation to file those schedules of assets and liabilities. Wolfgang Rohlball was number 1. Not one person on that list filed those schedules of assets and liabilities. It was a violation of the court's order then, and Mr. Robal remains in violation of that order now. If schedules, accurate schedules of assets and liabilities had been filed, then none of this would have happened. That's the root of the problem here. Now, this is important because under U.S. bankruptcy law, as an unscheduled asset, the alleged investment remains the property of the EuroGas bankruptcy estate. And it remains, and this is important, protected by the automatic stay that is triggered in bankruptcy from further transactions dealing with the investments or the assets of the debtor. There's an automatic stay that's put in place. Now, this position was fully supported by our expert, Ms. Annette Jarvis, a prominent member of the Utah Bankruptcy Bar and a partner at the international law firm of Dorsey and Whitney. The tribunal will recall that Mr. Garavi unsuccessfully tried to have Ms. Jarvis's report stricken from the record. Given how devastating it is to their case, that's not surprising. His attacks were based on the fact that while she was at a different law firm than the one she is at now, she represented an individual named Steve Smith. Steve Smith was the trustee in an earlier bankruptcy called the McKenzie bankruptcy you'll have read about in our papers. That's the bankruptcy on of which the court issued that $113 million judgment that I described earlier. And that's the court decision that made those very serious and grave findings against Mr. Robal for fraud, conspiracy, and providing false testimony. Mr. Smith was a trustee in that case. Ms. Jarvis was not involved in that case at all. Mr. Smith had a judgment against EuroGas because of that bankruptcy, which went unpaid. And so he involuntarily caused EuroGas 1 to be put into involuntary bankruptcy because the judgment was unpaid in Utah, which is the jurisdiction in which EuroGas 1 was incorporated. And there he retained Ms. Jarvis as local counsel. Now, Mr. Smith himself is a lawyer, but he retained Ms. Jarvis to be local counsel. And I should point out, Ms. Jarvis openly disclosed this fact in her first report. Now, based on these factors, claimants sought to strike her report on the basis, and I'm quoting now from their letter, it was only to conceal her professional negligence toward her former client that she agreed to issue an expert report in this arbitration. That is an extraordinary comment from about a distinguished member of the United States Bankruptcy Bar. In fact, the claimants admitted in that correspondence that they too sought to hire Ms. Jarvis to be their expert in this arbitration, and she didn't respond to their email. So it is particularly curious that they would now criticize the Slovak Republic for engaging her as an expert. In any event, her former client, Mr. Smith, a lawyer himself, has never, ever suggested any dissatisfaction with the professional services she rendered so many years ago. And Ms. Jarvis explained to the tribunal in that correspondence, she issued a statement we attached, that the issues on which she is now opining before you were not the issues on which she gave any kind of legal advice in that case. All of the factual information contained in her report came from publicly available sources and documents. And nothing set forth in her report is based on any type of privileged or confidential information. To be absolutely clear, neither she nor her former client have any interest in this arbitration. I might also point out she's the partner in charge of bankruptcy at Dorsey and Whitney. She's a member of her firm's management committee, and she recently received the Utah Lawyer of the Year award in her state, not just in bankruptcy, across all practice areas. The allegation that she is an expert in this proceeding to cover for professional negligence is both disappointing and without colorable basis, and it warrants no further response. Now, in her report, Ms. Jarvis explains that the talk interest could not be abandoned and must still be part of the bankruptcy estate because it was never listed on schedules of assets and liabilities since none were filed in violation of the court order. The claimants, on the other hand, have offered the expert report of Mr. Lita, Mr. Merrill, who somehow opine that a trustee can abandon an asset even though it's not scheduled. All you need to do is look at the statute that governs abandonment in the United States. And we will come to that statute soon. I think I'm getting ahead of myself. We'll come to that statute soon. Now, given EuroGas's proposed deal with the trustee, you might wonder What role, if any, the members of this tribunal have to play in resolving the disagreement between Ms. Jarvis on the one hand and Mr. Lita on the other. That is, on resolving the question of whether the bankruptcy estate owns the asset or whether it was abandoned. And the answer, members of the tribunal, is that unless the trustee changes her mind and declares whether the estate owns it or not, and assuming that's approved by a court, you, members of the tribunal, will have to answer this question. And the reason is because the trustee's proposed deal with EuroGas 2 right now does not take a position on whether the estate owns it or not. It simply says that the trustee is selling whatever interest it may have in the estate. It's what under US law we call a quitclaim. You're not making a representation as to whether you own it or not as the seller. It means you, members of the tribunal, will have to decide this issue. Now, claimants will say, but we bought whatever interest the estate has nunc pro tunc, which can be understood as meaning retroactively. But as the tribunal is all too aware, even if the trustee's proposed abandonment is retroactive, or purports to be retroactive, under public international law, an investor cannot use a retroactive transaction to create investment protection that did not otherwise exist. Let me give you an example. I have a colleague down the table, Mr. Pekash. Mr. Pekash is a national of the Czech Republic. Let's assume he makes an investment in the Czech Republic, and the Czech Republic expropriates his domestic investment. He then sells his rights to the investment to me. I'm a US national. And as we're permitted to do under civil law, we make our deal retroactive. Can I bring a claim for a violation of the US-Czech bilateral investment treaty? Of course not. And Mr. Pekash and I know this all too well, having dealt with this issue with one member of the tribunal, sitting as chair in the Phoenix Action versus Czech Republic case, where that issue was before the tribunal, and we know how they ruled. The point is, even if the trustees' deal were to be approved, and we do not think it will be, but even if it were to be approved, they haven't solved anything. It would still not solve the jurisdictional problem. And that means you will have to decide whether the asset was abandoned or not. Fortunately, the law is clear on that point. If we go to the next slide, the law is so clear on the point that even EuroGas counsel has agreed with us. This is the document I showed you earlier, where Ms. Burton, counsel for EuroGas, stated, the reopening of the case will necessarily carry with it the conclusion that the asset was not abandoned and EuroGas 1 still owns the claim, and EuroGas 2, the only EuroGas entity that's a claimant in this arbitration, does not. It is not surprising that she took this position. She's absolutely right. Assets cannot be abandoned by operation of law in the United States unless they are listed on schedules of assets and liabilities with the bankruptcy court, period. Indeed, the statute to which I referred before specifically points this out. Now, this is the statute that governs the abandonment of property in U.S. bankruptcy court. You'll see there are various provisions that contemplate court approval. One of them allows assets to be abandoned with court approval. We all know that didn't happen here. It's not even argued by the claimants that it was with court approval. The only provision that claimants say could apply here is subsection C. And it states any property scheduled that is not otherwise administered can be abandoned. But the word scheduled is right there. There's simply no way around it. That's the only mechanism by which an asset can be abandoned by operation of law, and it explicitly requires the assets to be scheduled. It is undisputed they weren't here. The case law has confirmed this point, and I have here just a number of cases. I'm not going to take you through each one. I want to spend just a minute on the very first one, but after that, we're going to move through them very quickly. The first one I'm going to focus on because it's a case called Brumfield. Brumfield is a case we discussed with some prominence in our last brief. We do so because it's a recent decision from the 10th Circuit BAP. This is the judicial body directly above the Utah court. And in Brumfield, there was a debtor who listed in schedules, so she did more here than EuroGas, certain mortgages, but didn't disclose, and I really want to call your attention to this because I'm going to come back to it in a minute, did not disclose that there may be litigation, claims she may have arising out of those mortgages. She simply listed the mortgages, okay, but not the claims. Very important. She later tries to bring a lawsuit against the bank that held those mortgages. The courts conclude because the claim, even though the mortgage was listed, because the claim, the litigation arising out of the asset was not scheduled, the assets could not have been abandoned. The trustee had them, and you know who bought that claim? The bank. It bought the claim against itself. And the 10th Circuit courts concluded that that was perfectly appropriate. Nothing wrong with that at all. This case makes clear if the assets, including claims, are not scheduled, then they cannot be abandoned. Now, as I said, if we go to the next slide, you'll see there are a number of cases from the 10th Circuit that also stand for this proposition. The circuit courts, by the way, are the courts of appeals, the United States courts of appeals, federal courts in the United States. They're all over the country. As you can see, this is hardly something unique to Utah. Not only is it the 10th Circuit, but the 1st Circuit, the 5th Circuit, the 6th Circuit, the 8th Circuit, the 9th Circuit, the 11th Circuit, and lower courts are of the same opinion. These are all courts directly below the United States Supreme Court. And indeed, even in the Brumfeld case, they tried to appeal it to the U.S. Supreme Court, and the U.S. Supreme Court wouldn't even take it. Now, despite that crystal clear proposition of law, the claimants have told you that the trustee had subjective knowledge of the asset. So even though it wasn't scheduled, his subjective knowledge was enough to allow for the abandonment. But the case law is equally clear, and of course it has to be the case, based on the proposition of law I just described, that it has to be scheduled. It must be the case that the trustee's subjective knowledge is irrelevant. Here's a case where the court in the United States said the bankruptcy court will not do a case analysis, a case-by-case analysis, so of what the trustee's knowledge was and whether that knowledge was enough to result in abandonment of an unscheduled asset. Thus, the debtor did not properly schedule the cause of action. It was not abandoned by operation of law pursuant to, and you see the subsection C in that statutory provision. That's the operation of law. Okay, but even if you were to look at the trustee's subjective knowledge, and you're not, the case law is clear, but even if you did, there is nothing to suggest that this trustee had full disclosure of the talc interests, or, and I'm going to focus on this more particularly, this ICSID claim. Indeed, EuroGas 1 CFO Hank Blankenstein told the trustee under oath that EuroGas 1 did not own the talc mines. If you look up on the screen, you'll see a cross-examination that the trustee did of Mr. Blankenstein. This is before EuroGas and Mr. Robal started to refuse to participate in the bankruptcy and started to refuse returning counsel's calls. And the question is asked, and that is the property that is referred to as the talc deposit. Is that correct? Yes, correct, correct. Now, isn't it true that EuroGas does not even own the talc project? That's correct. That's what he told the trustee. Now, the claimants will tell you today that Mr. Blankenstein was only talking about Belmont's 57% interest, not EuroGas's 33% interest. They've said this before. When you hear that, members of the tribunal, please read the transcript. It is clear that Mr. Blankenstein led this trustee to believe that EuroGas 1 has no interest at all, and I'll show you this because on the next slide, Mr. Smith, the trustee, says to the court, I'm trying to show, Your Honor, that the assets have been dissipated, that there is really nothing left. To suggest this trustee thought he was abandoning an ICSID claim worth the kind of money that claimants are now claiming for is preposterous. Now, the claimants will also cite you to an SEC filing, which was attached to one of the trustees' briefs. I think this is, if memory serves well, C69. It's a brief the trustee filed with the court. The brief says nothing about the talk interests, but it attaches an SEC filing, and buried in the SEC filing, they talk about the talk interest. What do they say about it? They say the talk interests have been revoked because the excavation area was reassigned. Again, reinforcing there's nothing for the trustee to deal with. There's no asset of value. There is no mention, not only of this ICSID claim, but any present or future litigation that could arise out of the talk interests. And that's why I focused you so much when we were reviewing the Brumfeld case on the fact that even though the mortgage in that case had been scheduled, the claim itself was not, and that was found, even there, not to have been properly disclosed to the trustee. So when did EuroGas finally list in its SEC filings this litigation, the ICSID claim and the related litigation? It won't surprise you to learn it was after the bankruptcy closed. EuroGas created, Mr. Robal created another entity by the same name, the same address, the same officers and directors. To the outside world, everyone thinks it's the same company, so he could wait until the bankruptcy was over and exercise assets like this ICSID claim that were never disclosed to the trustee. And for that reason, they did not publish in their SEC statements that the ICSID claim was something they were even contemplating until after the bankruptcy was over. Now, as I noted to you, the case law is uniform that the actual knowledge of the trustee is irrelevant. So you don't need to wade into this analysis about what the trustee knew or didn't know. But even if it were relevant, you can see the trustee did not have full disclosure. And because of that, the claim was not abandoned, and because the estate still owns the ICSID claim, EuroGas 2 is prosecuting a claim before you right now that it does not own, which is why they're trying to pay $425,000 in other consideration for it from the estate now. Now, if the tribunal reaches this conclusion, you need not wade into the complexity I'm about to get into. With that conclusion, the tribunal has no jurisdiction over EuroGas 2, and the matter is over. I'm going to pause here because I am about to address the complexity now. I'm going to assume that you disagree with the argument I just made, and that you conclude that somehow EuroGas 1, despite being a dissolved, defunct company in the bankruptcy, somehow emerged with this claim. As you will see, there are numerous other jurisdictional problems in that scenario that still remain. And this is paramount. Even if the trustee's deal gets approved by the court later this month or the next month, these jurisdictional problems still exist. And that's even if you conclude it applies retroactively, which, as I told you, you can't do. So even if the deal gets approved, even if it applies retroactively to create ICSID jurisdiction where it doesn't otherwise exist, all of these jurisdictional problems still remain. Okay. Let's first turn to claimant's merger theory. Now, in one of the iterations of its jurisdictional case, claimants argued that EuroGas 1 merged with EuroGas 2 and somehow the ICSID claim then magically transferred from one to the other. How did these companies, quote unquote, merge? Well, claimants have come up with a number of different theories. As I noted to you, one of them was what's called a Type F reorganization, which was effectuated by a joint stipulation signed by the officers and directors of the company in 2008. You saw already that they abandoned that argument. I had showed you that. They also seem to suggest, although it's not entirely clear, that it might have been statutory merger. Their merger is a state law doctrine because corporations and corporate law are a matter of state law. There are statutes in every state that govern when companies can merge. Now, to do that, you have to file articles of merger with the division of corporations in the relevant state. Now, that makes sense because the point is that the states want the public to be able to have access to that information. Right? This is not something that's supposed to be done in secret. And the merger is effective only when the articles of merger are actually filed in that division of corporations. Now, there is no dispute that no articles of merger were ever filed here. How was it transferred then when we pointed this out? They instead reverted to this merger under de facto common law merger. Let's go to the next slide if we could. Okay, we'll come to that shortly. Now, this common law merger doctrine does not exist to transfer assets from one corporation to another. What is de facto common law merger? It is a common law doctrine, which means it's been created by judges in the case law, okay? And it arises in a situation where you have one company that transfers its assets but does not merge with a second company. So the second company now holds all the assets. And there are creditors that are still owed money from the first company. So they sue the successor company before a US judge, and they ask the judge to consider the two merged for purposes of attributing the liabilities of the first corporation so that the corporation can't escape its obligations just by transferring its assets from company to company to company. In other words, it's a doctrine to punish successor companies. It has never, and the claimants have not cited a single case, been used to effectuate corporate mergers. Think about it. If it did, what would be the point of the statutes requiring the articles of merger? If one could accomplish this simply by doing nothing or by signing a joint stipulation in secret, why would anyone comply with the statute? Moreover, it's a common law doctrine. It has to be declared by the judge. The judge has to say, yes, I'm going to hold the successor corporation liable for the predecessor's liabilities. There's never been anything like that here. Think about the point of the statute from the respective states across the United States and why they have those requirements for filing, so that it not be done in secret. Now, because we have a capitally starved company on the other side, I think the absurdity of this argument isn't as clear as it would be if we considered capitally healthy companies. Just imagine for a moment that Lufthansa and United secretly merged, but didn't tell anyone. They have a secret document between them. They're publicly traded, just like EuroGas was. They don't tell the market. You've never seen it in any SEC statement or public filing that EuroGas made that it did this merger. They don't file anything with the respective states of incorporation. It's just done in secret. I mean, that would be a laughable proposition. And that is the substance of this argument. Okay. That's merger. I think understanding that that argument can't possibly work, they then offered the McCollum theory in their last brief. So now we turn to McCollum, and this is where it does get complicated. As I said, the McCollum theory, the totality of what we've been told about it, is up on the screen. The theory appears to be that EuroGas 1, and again, this is on the assumption that it emerges from bankruptcy with the asset, EuroGas 1 transfers the claim, I should say transfers its shareholding in EuroGas GmbH, the Austrian entity, to a UK entity in 2007. So if you look at this paragraph here, let me see if my pointer will work. You see here it has the date, 2007. That's when EuroGas 1 transfers its interest in GmbH to McCollum. We have that date. But as I will show you, that's EuroGas 1 transferring the asset away. And as I'll tell you, that means that the US Slovak BIT stops to apply. And then here's the important point. The EuroGas 2 company, that's what they just call EuroGas, thereafter acquired the entirety of McCollum's issued shares. The implication being that they therefore then reacquire indirectly the EuroGas GmbH shareholding. Do you notice there's no date? That's the investment. In any event, we know it has to be after 2007, and it appears, they say, it was before June 2012, because then what apparently happens is Macallan transfers its interest to GmbH to a new Swiss subsidiary, EuroGas AG. All right. Here's where it gets complicated, because if this new theory is correct, it would mean, and I direct your attention to the next slide, that the tribunal's tracing two assets now. What do I mean by that? EuroGas 1's ICSID claim relating to the 2005 reassignment of the excavation area, right? The ICSID claim that the excavation area was reassigned unlawfully. That is an asset of EuroGas 1. It's not an asset of GmbH. It can't be, because GmbH is an Austrian entity. Only the US entity can own that asset. So when you transfer GmbH, you can't transfer the reassignment claim. It stays with EuroGas 1. GmbH goes to Macallan. So the second asset we have to trace is the GmbH shareholding. This reassignment claim stays with EuroGas 1 under this hypothetical. The GmbH shareholding gets moved to Macallan. And a mess ensues, because now you have to trace both assets throughout time, and they're moving around, and you have to determine what it means for your jurisdiction at all relevant points in time. This is the complexity that I warned you about. Now, you might also think, as you know I'll get to, totally different jurisdictional objection relating to Belmont. Belmont sold its 57% interest to EuroGas, right? They did so in 2001. How does that fit into this? And the answer is that that 57% interest that Belmont sold EuroGas in 2001, remember EuroGas has its own 33% interest under the GmbH shareholding, that 57% interest was not held through GmbH or any other subsidiary other than Rosman. It means that the 57% stays with this reassignment claim. Only EuroGas's 33% goes with the GmbH. Is it fair to ask, if this is really what happened, why didn't claimants tell this tribunal this story in its first filing, or its second, or its third, fourth, fifth, or sixth? The seventh submission is the first time we heard anything about this. I should also tell you that Macallan is a related party again. These are all trafficking in corporate shells. In fact, Mr. Robel held a position in Macallan. And of course we know that because even claimants, quote, stated that EuroGas caused Macallan to transfer the EuroGas GmbH shareholding. Okay, so now we're tracing two assets, and you have to determine at each point in time what your jurisdiction is. The way I'm going to try to simplify this is by looking at 4 different points in time. Let's first start with prior to 13 July 2007. What's that date? That is the date we are told that Macallan acquired from EuroGas 1, that EuroGas 1 transferred the GmbH shareholding. So before that time, and under the assumption the asset was not abandoned, I should say was abandoned, and EuroGas 1 emerged from the bankruptcy with the asset. Under that assumption, before this date, EuroGas 1 had both. It had both the reassignment claim, the ICSID claim, and the GmbH shareholding. It had both. What happens after that date? Well, on that date, EuroGas 1 transfers away the GmbH shareholding. At that moment, the US Slovak BIT ceases to apply to the talk interest, because it transfers it to a UK entity that doesn't enjoy any protection under the US Slovak BIT. Now, I say until some unspecified time. Why? Because we don't know when EuroGas 2 acquired Macallan and therefore the GmbH shareholding back. They didn't tell us. I already told you in the prior slide that there simply is no date specified. Now, Mr. Chairman and members of the tribunal, last week, the claimants submitted 5 new documents concerning Macallan. they blamed us for not putting these documents into the record to carry their burden of proof. And in the cover letter, in a very strongly worded cover letter from counsel, we were told that it was outrageous for us to make these complaints when we had had the documents produced to them, and asked you to introduce those documents. You agreed to introduce those documents, so I will address them now briefly. Those documents do not tell you when EuroGas 2 became the shareholder of Macallan, and therefore GmbH, and therefore Rosman, and therefore the Talc interests. They don't tell you that. There are 2 agreements out of those 5 documents. One of those agreements is in a conditional agreement. You will see it has a variety of different conditions in it, and we do not know if those conditions were ever satisfied, and if so, when they were satisfied. So it did not effectuate a transfer of shares. And the other document is an option to purchase shares in the future. It too is not an agreement for the purchase of the shares. There is a deed showing that at some point in time, the shares were transferred from EuroGas 2 to some new entity, but that document does not tell you the date on which EuroGas 2 purchased its interest in Macallan and therefore GmbH. And that's the investment at issue. We still don't know. Okay, now we go to some unspecified time between 13 July 2007 and 4 June. Now we start with the unspecified time too, because again, that's whenever EuroGas 2 purchased its interest in Macallan and therefore GmbH, and up till 4 June 2007. Actually, before I do that, let me go back to the prior time period, point number 2. As I noted, as of 13 July, the U.S.-Slovak BIT ceases to apply. I should make clear the reassignment claim itself, not the GmbH shareholding, but the reassignment claim would have stayed with EuroGas, right? And the point is the tribunal's jurisdiction ratione temporis over any alleged breaches of the U.S.-Slovak BIT ceases on 13 July 2007. And this is important because the tribunal will recall that claimants complain about a number of court decisions and their implementation by Slovak authorities, and they all occurred after that date, after the U.S.-Slovak BIT stopped applying. Okay, now we move to the next time period, point number 3 here below. Claimants state that, and this was in the paragraph we saw earlier, EuroGas 2, the claimant, acquired the entirety of Macallan's issued shares at some unspecified time, and then in June 2012, EuroGas 2 indirectly acquires this asset. What does it acquire? It is a dead Rosman company whose shareholding has not enjoyed any BIT protection since Macallan is now a UK company, and this is important, with notice of all facts that had occurred prior to that date. And we all know doctrines where investors take with full notice of facts that had previously occurred and cannot complain about them later. Okay. EuroGas 2 itself can only bring claims relating to the U.S.-Slovak BIT after its alleged acquisition of the shareholding in Macallan, whenever that was, which we still don't know. And then finally, after 4 June 2012, that's the date on which EuroGas 2 allegedly caused Macallan to transfer its interest in EuroGas GmbH, and thus to Rosman, to EuroGas AG. Because of the total lack of information provided by claimants about this transaction, neither the Slovak Republic nor the tribunal has any way of knowing what impact it has on this tribunal's jurisdiction. Where does this leave us? And again, we are presuming abandonment, which we deny. We're presuming that if the trustees deal with EuroGas 2 is approved by the judge and can retroactively create exit jurisdiction, which we deny, we're assuming all of that. Even with those assumptions, this is where we're left. These are the jurisdictional problems that remain. Number 1, the U.S.-Slovak BIT ceased to apply as to EuroGas 1 when it sold the GmbH shareholding, allegedly, to Macallan in 2007. Number 2, EuroGas 2's investment was not made until some unspecified time between '07 and 2012, when it allegedly acquired the GmbH shareholding indirectly through Macallan. Number 3, EuroGas 2 never reacquired the reassignment claim. Let me repeat that. EuroGas 2 never reacquired the reassignment claim, which is at the heart of the dispute, and that's the claimant in this arbitration. Number 4, the tribunal has no jurisdiction, ratione temporis, before EuroGas 2 made its alleged investment by acquiring Macallan, and we don't know when that was. We don't know when it occurred. Number 5, therefore, EuroGas 2 cannot complain of any actions that predated that point in time, including the 2005 reassignment. Number 6, EuroGas 2 cannot complain about the Slovak court actions that postdated its investment, because the investment, previously unprotected by a BIT because it bought it from a UK investor, and an asset embroiled in domestic litigation, is not protected under the Phoenix Action Doctrine, and it leads to the conclusion that the investor, when it made that alleged investment, took notice with all facts that had previously occurred and cannot complain about them now. As you can see, and as I warned, for the tribunal to rule in favor of EuroGas 2 on jurisdiction, it would have to make so many factual assumptions. It would have to untangle so many corporate shell games. It would have to overlook the complete lack of evidence supporting these transactions. It would have to undertake so many legal gymnastics that the exercise is quite literally dizzying. For all the reasons we've explained, EuroGas 2 does not own the alleged investment and has no standing before you. But now let's assume that all of that's wrong. Let's assume that claimants own all the relevant investments at all the relevant times. There is another reason why you have no jurisdiction, totally independent of the first, and it's because the Slovak Republic denied the benefits of the Slovak-US treaty. Members of the tribunal, we're all familiar with the case law on denial of benefits. This case is different. It's the first case in the history, to our knowledge, of investment treaty arbitration where the respondent state denied the benefits before the arbitration was commenced. We're aware of no time where that's ever happened before. Why is that relevant? Because we denied the right to arbitration itself. We all know in a treaty there are a bundle of rights: substantive rights, procedural rights. We all know there are cases that say you can't deny the arbitration right, but they're all ECT cases, and for good reason, because the ECT's denial of benefits clause says that you can deny only the benefits in, I think it's part 3, and the dispute resolution clause is in a different part. In this case, it's a US treaty, and so the US cases apply rather than the ECT cases, and there is no such limitation. So whereas the ECT cases, like Plama versus Bulgaria and the others, conclude that the arbitration right itself cannot be denied, that is not the case in the US treaties. The US treaty cases, and this denial of benefits clause in this US treaty is identical to the other ones that have been arbitrated before, have held that the arbitration right can be denied. And the cases are PAC-RIM versus El Salvador, Ulysses versus Ecuador. What does this mean? It means, coming to the other issue that always comes up in these cases, that we denied the right prospectively. We do not need retroactive application of the denial of benefits clause. We denied it before the arbitration right was exercised, and therefore it was a right not being exercised that we denied prospectively. So any debate about prospective versus retroactive is irrelevant. Now, to be sure, we think it applies retroactively as well, even to the substantive provisions of the treaty, but you need not reach that decision because we denied the arbitration right prospectively. Now, it may surprise you to know that, in fact, that issue, while I thought it was important to describe it to you, is not disputed between the parties right now. If you go to this slide here and you look at the claimant's reply, in their denial of benefits section, they do not make the argument that retroactive versus prospective even matters here. They don't quibble with it at all. It's an undisputed point now. They did not dispute that a denial of benefits can apply even retroactively, even the substantive provisions of the of the treaty. Nor did they dispute that we have the right to deny the arbitration right itself. That's not in dispute. Nor did they deny that Mr. Rollball that EuroGas 2 is controlled by Mr. Rollball, who is a national of Germany, which is considered to be a third country within the meaning of Article 1.2 of the U.S.-Slovak Bilateral Investment Treaty. And can you go back a slide? Just for the tribunal's benefit, this is the letter where the Slovak Republic denied benefits. It was on 21 December 2012, well before the arbitration right was exercised in this case in 25 June 2014. So, to the extent that claimants previously argued these points, they are now abandoned. So what is claimants' argument? There are a variety of arguments. In the interest of time, I'm not going to take you through each one, but the one that they seem to focus on the most is that EuroGas does have substantial business activities in the United States. So I'm going to spend just a minute on that. As to the other arguments, we've fully set them forth in our brief, and the tribunal can read them at its convenience. Putting aside for a moment the question of who has the burden of proof on this issue, and I'll return to that at the end of my presentation, the Slovak Republic has offered voluminous evidence that EuroGas 2, as well as EuroGas 1, if you want to include that in the analysis as well, had no real business activity in the U.S. during the relevant time. We have shown that, number one, EuroGas has not conducted any material operations in the U.S. from its creation in 2005 to the present. Number two, EuroGas 2 has been managed outside of the United States. We know it's been managed in Canada, Western and Central Europe, most recently in Austria and Switzerland. We know that Dun & Bradstreet reports have stated that EuroGas 2 has been inactive since at least 2 December 2010, well before this arbitration. Number four, EuroGas 2 maintains no physical office in the U.S. Its purported office in New York is a mere mail drop. Number five, EuroGas 2 has repeatedly failed to meet its statutory requirements to file audited financial statements for the periods ending 2007, 2008, and 2009. EuroGas 2 was deregistered by the SEC on 30 March 2011 for non-compliance with U.S. securities laws. Number seven, EuroGas has no direct operating U.S. subsidiary since its bankruptcy. And number eight, EuroGas, by its own admission, lacked the ability to pay its auditors as far back as 2003, which coincided with its administrative dissolution. The only activities that claimants have been able to point to are lawsuits brought against EuroGas and shareholdings, idle shareholdings in companies. But as the tribunal in PAC-REM versus El Salvador confirmed, and we cite this in our brief, the mere shareholding in another entity is not enough to give rise to substantial business activities in the U.S. One can hardly expect the Slovak Republic to do more. Any possible evidence of substantial business activities would be in the hands of the claimants. And perhaps for that reason, the tribunal recognized in Procedural Order Number 4 that it is not the Slovak Republic that bears the burden on this issue, even though we've been told that we haven't satisfied our burden by claimants. In fact, during document production in this arbitration, the Slovak Republic requested, and you can see the request up, it's the top box, documents showing any business activities of EuroGas 1 or EuroGas 2 in the U.S. since 1998. You denied that request, and your reasoning was claimants have the burden of proof. They've had every chance to put evidence showing EuroGas 2's substantial business activities in the U.S. They've failed to do so. Now that concludes my presentation on why the tribunal lacks jurisdiction over EuroGas 2. I now turn to Belmont. The first reason the tribunal lacks jurisdiction over Belmont is that it sold its shareholding in 2001. And it told the police it did so, it told investors it did so, it told the marketplace it did so. Now to set the stage for this, Let me begin by noting the following. What we have seen in this case is a pattern of vaguely worded contracts, intentionally vaguely worded contracts between EuroGas and Belmont and other related companies. They're vaguely worded between affiliate companies, insiders, often acting in tandem to achieve common objectives. Often these agreements provide that they will only take effect if certain conditions, vaguely worded conditions, are satisfied or not. Now, why do they do this? They do this so that when it suits their interest, they'll say it's a sale, it occurred, it's a transaction completed. And when it doesn't suit their interest, they'll say, no, the deal hasn't been concluded yet. They give themselves the freedom to take whatever position suits their interests. As you will see, I'm going to show you numerous statements where Belmont told the world we sold our 57% interest. And I'll show you numerous statements from EuroGas telling the world we own now the 57% interest. And then later today, they will show you different statements where they say the opposite. They have the burden to establish the facts necessary for your jurisdiction. These contracts are drafted intentionally so they can do this. So what is the deal that Belmont signed in 2001 to transfer its 57% shareholding to EuroGas 1? The document is up on the screen. Now, yet again, the claimants did not notify you of this. We had to find this ourselves again. It is a sale purchase agreement dated 27 March 2001. In general terms, this SPA provided that Belmont would transfer its 57% interest to EuroGas 1, and in exchange, EuroGas 1 would pay Belmont 12 million of its own shares. This becomes very important later. So Belmont and EuroGas, Belmont will give it its 57% interest in Rosman, and in exchange, EuroGas will give it 12 million of its shares. This agreement is governed by British Columbia law. We have an expert on British Columbia law. His name is Mr. John Anderson. He'll be with us later this week. He concluded in his first report and reiterated it in his second report. As you see up on the screen, this actually is his report. Belmont, quote, transferred to EuroGas 1 ownership of Belmont's 57% interest in Rosman and retained the shares as a collateral interest. I'll read the quote. Quote, retained a security interest in the 57% to secure EuroGas 1's compliance with other covenants under the agreement. Those other covenants were effectively provisions that would require EuroGas to issue additional shares depending on various events. 57% gets sold, but Belmont keeps the shares as security, collateral. Now, claimants dispute that the 57% interest was transferred. They have no British Columbia law expert to support their position. No one who is qualified under British Columbia law has agreed with their position. Their arguments come from their advocates in this arbitration who are not independent and who are not experts qualified in British Columbia law. But perhaps most tellingly, the claimants themselves, these parties, Belmont and EuroGas, agreed with Mr. Anderson's analysis before this arbitration started. And now I'm going to show you statement after statement after statement. If even one of these statements existed in an ordinary course, it would be dispositive. Look at how many we have. In its audited financial statements of 2001 and 2002, Belmont declared to the investing public that it had, quote, sold its 57% interest in Rosman effective 27 March 2001, and it states that it held, quote, the shares, and this is the key part, as a collateral measure only as security. And it also stated that EuroGas acquired effective control of Rosman as of that date. Now, you noted this quote comes from the audited financial statements. Audited. That means auditors went in and presumably read the contract as well. And the auditors agreed with Mr. Anderson's conclusion. The next statement. Belmont publicly informed its shareholders in the market in its 2002 annual report that it had sold its 57% interest in Rosman effective March 2001, telling shareholders this. What about EuroGas 1? EuroGas 1 made its own comments to the marketplace. In its annual reports for 2002 to 2005, it states that by virtue of ownership of Rosman and the talc deposit, EuroGas bears the full responsibility to fund the development costs, full responsibility to fund the development costs necessary to bring the deposit to commercial production. The next statement. Belmont publicly disclosed in its audited financial statements for 2004 and 2005 that it held a, quote, collateral security interest, which is not considered by management to be a controlling or significant interest in the shares or the operation of Rosman. The next statement. This one is different than the others. This is EuroGas going to a third-party purchaser and representing that it owns the 57% and offers to give the third-party purchaser an option on the 57%. How can EuroGas be offering something it doesn't own? Because under claimants theory, Belmont owns it. Now, I want to be clear that our expert, who is with us today at the very end of the table, Mr. Sirshar Qureshi, he has done a forensics analysis of all the shell games that have gone on here. That's why they're not crossing him. He has serious questions about the bona fides of this particular transaction. The counterparty here was an entity called Protech Industries. But regardless of the bona fides of this transaction, it is clear that EuroGas is representing to a third-party purchaser its control over the 57% interest. The next document. Belmont thereafter threatened to repossess. You don't have to repossess something you already have. They threatened to repossess the 57% interest that Belmont had previously described in its financial statements as a collateral interest. The next statement. Belmont thereafter agreed not to foreclose on the 57% interest. That, of course, means it's collateral. And finally, and if there's any admission in this case you should pay attention to, it's this one. Mr. Adjagos, the head of Belmont, gave a sworn statement to the Slovak police in 2009. And he stated, quote, Belmont Vancouver sold its business shares around 2002, it should be 2001, to company EuroGas, and here's the key part, we, Belmont, did not incur direct damage. From what? From the actions at issue in this arbitration. If you read that affidavit, they're about the actions at issue in this arbitration. We, Belmont, did not incur direct damage. Why? As his statement states, because we sold the business shares around 2002. This statement, members of the tribunal, was given under oath. On the next slide, you will see a criminal provision. He was warned that his statement, if untrue, would result in criminal sanctions. Either he was lying to the Slovak police in 2009, which carries with it criminal sanctions, or he is lying to you now.
Is it Mr. Robal or Mr. Agiagos?
Mr. Adjagos.
Yes, because on the slide.
The slide is incorrect.
Yes.
Oh, I think I skipped this, Mr. Chairman. Let me be clear. This is a statement from Mr. Robal, in which he told the Slovak authorities that EuroGas owns the 57% that Belmont now owns. So this is slide 72, okay? The sworn statement with the omission I just mentioned was 73, and it was my mistake. I skipped over 72. I should not have. I apologize. Okay, go to the next one. This is the admission. This is the admission from Mr. Adjagos, stating Belmont was not damaged because it sold its shares in 2002. He actually spoke incorrectly. It was 2001. And you can see his signature there. As I mentioned, he was either lying to the police then or he is lying to this tribunal now. Okay. There are one or two other statements. The next one is a statement from EuroGas, so we have both parties announcing that this transaction is done. As I said, they will show you contrary statements in their presentation today, but that's the whole point of why the transaction is structured this way. And again, EuroGas tells the marketplace, this in fact is to the German stock exchange, and it states EuroGas Inc. is the holder of 57% of the shares. That's the investment that Belmont's claiming before you today. Okay, now we go to the next one. And this one is important because, as I mentioned, the consideration under the deal was that Belmont sent 57% to EuroGas, and EuroGas sent 12 million of its own shares to Belmont in return. Now, why is that important? If there were any remaining doubt that this transaction occurred, this erases it. Both parties, having given that consideration, took that consideration and sold it on to third parties. In other words, Belmont receives the 12 million EuroGas shares in exchange for the 57% and then sold it to a third party. And this is audited, consolidated financial statements where Belmont states at the year end, all of the original 12 million shares received from EuroGas Inc. have been disposed of for proceeds of approximately $1.37 million. Okay? But what about EuroGas's consideration? What did it receive under the deal? It received the 57%. It sold that to a third party. Let me repeat that. EuroGas sold the 57% onto a third party. And if we go to the next slide, this is from a filing from EuroGas AG made to the German stock exchange, and it states, in the agreement, EuroGas Inc. expressly confirmed the rightful title of EuroGas GmbH to the 57%. GmbH is a different company. So I can't emphasize enough how important the fact is that they exchanged consideration and then sold the consideration on to third parties, both on Belmont's side, the 12 million shares, both on EuroGas's side, the 57%. Now, Mr. Anderson goes through in some detail in his report why the agreement, the actual SPA, transfers the 57%. And Belmont only holds on to the shares as collateral. He explains why under British Columbia law that would be the result. Having just talked about it with Ms. Jarvis, she tells me in bankruptcy proceedings, these types of situations where agreements aren't clear on who's holding legal title, it's frequently interpreted this way. Mr. Anderson will tell you how under British Columbia law, that is the only reasonable interpretation. And again, there is no other British Columbia law expert in this case. I could take you through Mr. Anderson's analysis, but we have outlined it fairly clearly, I think, in our reply, and it would take a lot of time. So in the interest of time, I'm just going to try to summarize it in a paragraph. Claimants will tell you there are conditions precedent in that contract that have not been satisfied. Under Article 2 of that contract, in fact, they all have, and I could take you through them, and if it comes up during the hearing, we'll do so in the closing argument. But the real argument is that in Article 6, which deals with the closing, there is a requirement, a condition precedent, that the deal will not be complete unless the value of the shares that EuroGas gave to Belmont, the 12 million shares, reaches a certain value on sale. As Mr. Anderson points out, that provision would lead to an absurd commercial result. Here's what would happen. EuroGas would receive the 12 million shares, and it could decide not to sell them at all. And Belmont, I'm sorry, could not sell the EuroGas shares at all. It would just hold on to them, and it would receive all the consideration under the contract, but have to pay nothing in return. Or it can do what it did, which is just sell it for an amount low enough to be under the amount in the contract. And then again, it would receive the proceeds, which we know were 1.37 million, and it wouldn't ever have to give over the 57%. That's an absurd result. And Mr. Anderson explains in his report why that type of deal would be construed by a British Columbia court to be a sale of the 57% while Belmont holds as collateral the shares to secure the obligations that EuroGas has under other provisions of the contract. And we know claimants agreed with that interpretation because they said in their SEC filings, we're only holding the shares as collateral. And we know their auditors agreed with that conclusion because they said so in their audited financial statements. Okay, as I say, that's the extent of the analysis I'll go into. I'm happy to go into it in more detail, but it, as I say, is time consuming. For these reasons, Belmont, having held the 57% interest merely as collateral, has no investment before you, and the tribunal has no jurisdiction. But now I want to assume that legal title was not transferred. Let's assume that Belmont retained legal title, which means they're not just holding it as collateral, as they told the marketplace. They have legal title to the shares. Even in that scenario, at a minimum, EuroGas was the beneficial owner of the shares. And this proposition is supported by all of the quotes I just read to you and reinforced by the repeated public statements from Belmont EuroGas 1 and EuroGas 2. There's one letter in particular I'd like to draw your attention to on this issue. It is a letter from September 24th, 2004. It's a joint letter executed by Mr. Rollball and Mr. Adiagos, and the parties recognized that EuroGas Inc.'s 57% interest in Rosman, quote, currently standing in the name of Belmont. This is a joint acknowledgement and the most current authoritative statement from the parties to the SPA that EuroGas 1 was at a minimum the beneficial owner of the 57% interest and that Belmont remained the nominal owner only. Several members of the tribunal will be familiar with a case that I'm about to cite, which is the Occidental Petroleum versus Ecuador ad hoc decision. Before I get there, I would note that it is a general principle of public international law, and here I'm citing from David Biederman. He has a article on beneficial ownership in international claims. And his statement, and we quote this in our papers, is that the beneficial and not the nominal owner of the property is the real party in interest before an international court. Now, to the Occidental case, with which so many of us are familiar, the ad hoc committee concluded, quote, in cases where the legal title is split between the nominee and a beneficial owner, international law is uncontroversial. The dominant position, he of course notes that Professor Stern had correctly noted this in her dissent, the correct position was that the dominant position in international law grants standing and relief to the owner of the beneficial interest, not to the nominee. And then again, later in the decision, the position as regards beneficial ownership is a reflection of a more general principle of international investment law. Claimants are only permitted to submit their own claims held for their own benefit and not for those held, be it nominees, agents, or otherwise, on behalf of third parties not protected by the relevant treaty. And thus, even if one were to assume that Belmont only transferred beneficial ownership but retained legal title, something obviously dramatically different than just a collateral interest, even if that's the case, the tribunal still has no jurisdiction over Belmont. I come now to the final jurisdictional objection. Well, let's assume all of that is wrong too. Let's assume Belmont still retained the 57% interest despite all these statements to the contrary, despite selling the consideration under the agreement to third parties. The tribunal still doesn't have jurisdiction because the treaty under which it sues is a new Slovak-Canadian bilateral investment treaty, which in Article 15.6 states that the BIT only covers disputes, quote, that have arisen not more than 3 years prior to its entry into force. That is after 14 March 2009. That's the 3 years prior to its entry into force. This is in effect a statute of limitations. And we note it is binding on the tribunal and on the parties because the parties to this treaty, Slovakia and Canada, expressly agreed how they would treat succession under the treaties. Why is this so important? Because the claimant's colorable allegations, and of course the removal of the excavation area for the talc mine, occurred back in 2005. Now, in an effort to blur the chronology of facts, claimants had originally argued that all the Slovak Republic's alleged acts were a creeping expropriation. But they've abandoned that. They do not make that argument anymore. The argument now seems to simply be that the claims arose after 14 March 2009, even though we all know they arise out of the reassignment of the excavation area in early 2005. It is the one and only source of the dispute. The subsequent conduct of the Slovak authorities, whether it's the courts, the main mining office, the district mining office, those are inseparable from that original source. I'm not going to speak much about case law during this presentation, but Luchetti versus Peru is a particular case that bears mention on this principle. There, the tribunal held that because the subject matter and the purported new dispute was the same, it was a revocation of licenses, very similar to our case. The purported new dispute was in fact a mere continuation of the old dispute and thus arose prior to the scope of the treaty being triggered. Now, this Luchetti approach finds support in other international decisions. In Phosphates of Morocco, the Permanent Court of International Justice similarly confirmed that a dispute may only arise out of its quote-unquote real causes, as opposed to situations or factors that merely follow up or confirm the real causes. Now, the main authority that the claimants cite to you is another case you're very familiar with, Yandanol versus Egypt. It's the only case on which they rely for the proposition that judicial treatment of an earlier claim gives rise to a new investment dispute. But, as you know, that dispute was very different. Because in that case, the dispute arose only with the judgment rendered by the Egyptian court. You'll recall there was a state attribution issue in that case. The Suez Canal Authority had entered into an agreement with the claimant that was purely contractual in nature, and the tribunal concluded that the Suez Canal Authority did not have the ability, its acts would not be attributable to Egypt. The Egyptian state only became involved later in the courts because it handled the claimant's lawsuits on the contractual dispute against the Suez Canal Authority. And so the investment dispute between the claimants and Egypt thus came into existence only after the state became involved. Here, in sharp contrast, the conduct of the Slovak Republic was not a new intervening factor when the judicial and quasi-judicial authorities became involved. Rather, the Slovak authorities merely pronounced themselves on the legality of the reassignment under Slovak law. In other words, these proceedings could have only remedied, not worsened, Belmont's position following the reassignment. The one and only source of the dispute, the real cause, according to claimants, the real cause of the dispute was this 2005 reassignment of the excavation area. Indeed, Belmont itself articulated that an investment treaty claim had arose before the new treaty took effect. In November of 2005, the same year that the license was revoked, Belmont wrote to the Slovak Minister of Economy complaining about the reassignment and demanding that the Slovak Republic act in compliance with international investment law and threatening international investment arbitration. And thus, even under the claimant's own test, Belmont articulated an investment treaty dispute as early as November 2005. That's not all. More than 2 months earlier, in September 2005, Rosman, its alleged subsidiary, had challenged the reassignment before local courts. And on September 22nd, 2008, still well before the Canadian-Slovak BIT takes effect, Rosman's shareholder, EuroGas GmbH, wrote to the Slovak Ministry of Economy complaining about the treatment of Rosman's right to explore the excavation area. And I have some of these letters up on the slides, but I won't take you through them. And on 12 March 2009, 2 days before the Canadian-Slovak BIT became effective, Rosman filed an administrative lawsuit against the DMO's second reassignment. Rosman expressly stated that it is a, quote, company owned by foreign investors whose investments are covered by a specific legal regime under international agreements on protection of foreign investment. Even claimant's notice of dispute, which was sent on 23 December 2013, shows that Belmont had previously noticed a dispute. It expressly states that it had previously notified the Slovak Republic of the investment treaty dispute. So their own words show that the investment dispute had already arisen. Belmont itself had articulated a dispute before 1 March 2009. I'm not going to go into the cases that address when a dispute arises under or not. What those letters were meant to show you is even if you adopt their definition of when a dispute arose, Belmont itself had articulated that a dispute had arose prior to 14 March 2009. They offer two final arguments. One was raised on our pre-hearing call last Monday. This is their basis for trying to bring before you the Slovak Minister of Finance himself. They had said that the Minister of Finance himself had told them as late as May 2012 that the dispute was not yet ripe for filing of this arbitration and therefore should be delayed. That's what the claimants told you. Now, that is not what the minister said, and I can show you that the claimants themselves know he didn't say that, because they wrote a letter to the Slovak Republic characterizing the minister's comments before this arbitration was commenced, and here's what they said. They said, and this is a letter, this is the notice of dispute, 23 December 2013. He stated that the dispute could not be settled amicably. He's referring to settlement. He informed them that as the Minister of Finance, he could not settle the dispute under the policies of the Slovak Republic while matters were pending before local courts. He never told them they could not initiate arbitration or that a dispute had not arisen or that an investment treaty arbitration claim was not ripe. He simply said, we cannot enter an agreement with you to settle the case. That's all he said to them, and this letter is from the claimants themselves. This proves to you that the assertion, and now I'm quoting from their statement of claim, that the dispute was not ripe for filing of arbitration. He said nothing of the sort, and this shows they did not understand him to say anything of the sort. The second final argument they make is they point to Article 10.5 of the Canada-Slovak BIT, arguing that this provision means this arbitration can't be filed while there are still local court actions pending. That's not true. If you read that provision, it states that, in fact, an investor can submit a dispute to international arbitration, but must discontinue or waive domestic proceedings only where it seeks money damages. And Rosman's actions before the Slovak courts never sought money damages. And therefore, the proceedings do not fall within the scope of Article 10.5. And Belmont was not required to waive or stay them in order to bring this investment treaty arbitration. Now, if we all take a step back, there was an investment treaty under which Belmont could have brought its 2005 reassignment claim. In any of the years thereafter, it would have been covered under the prior Canada-Slovak BIT. It was effective from 30 January 2001 until 14 March 2012. That's when all the events that occurred in this case occurred. Indeed, the very last decision of the main mining office confirming the reassignment of the excavation area to Economy Agency was dated 1 August 2012, a mere 4 months after the previous Canada-Slovak BIT was replaced by the successive Canadian-Slovak BIT. In sum, Belmont had 7 years under the former treaty to bring this dispute to arbitration and did not do so. Members of the tribunal, that concludes my presentation on jurisdiction. You do not have jurisdiction over either EuroGas 2 or Belmont for a multitude of reasons. Claimants and not the Slovak Republic bear the burden of establishing the facts for your jurisdiction. They have utterly failed to carry that burden. And with that, I close the Slovak Republic's opening submission on jurisdiction.
Thank you, Mr. Anway. So we make a break until 4:15. So we resume. The tribunal will not have questions for the Utah law experts. So
Thank you.
they can leave if they want. Second, the tribunal has decided not to change its decision taken on reconsideration. That means it does not accept any of the two documents which claimant wanted to introduce, which I call the Keller documents. Now, who starts? Belmont or EuroGas?
Professor Meyer, we will start as Belmont.
Belmont.
Before we do so, we would like to introduce, hand you a binder, two binders containing documents on the record that we will be relying on during the opening statement. And I think my learned colleague representing the Slovak Republic and I have agreed that each would introduce 5 legal exhibits, each party. We would want the dissenting opinion of Professor Stern in the underlying Occidental arbitration and 4 BITs with the Slovak Republic. And I think there is an agreement on that, and respondent wants to introduce 5 legal exhibits that it has identified, and in principle we have no problems with that either.
So, just to confirm the agreement that Mr. Gravi and I discussed, in exchange for the new Slovak-Iranian treaty, which I understand has not yet taken effect, but I understand that at least the draft is what Mr. Gravi is proposing to put in the record, as well as Professor Stern's dissent. And if Mr. Gravi could confirm the 3 other legal authorities, the 5 documents that we would submit are either corrections to exhibits that were incorrectly filed, or they are documents that were quoted but not in our briefs or expert reports, but for whatever reason didn't actually make their way into the record. So none of this should be particularly new. Ms. Subakova is going to send a list of those documents to opposing counsel, and if you confirm you're comfortable with that, then we're comfortable with you relying on
Yes,
those
we
legal
are
authorities.
comfortable.
Thank you.
Thank you. Thank you, President Mayer, Professor Stern, Professor Gaillard, Belmont. I will, on behalf of Belmont, start this opening statement by addressing the merits and the jurisdictional objections that are specific to Belmont before giving the floor to Ms. Burton to present the jurisdictional objections that are specific to EuroGas. As I understand that EuroGas would not need to address the merits because it concurs with the position of Belmont. Before I start with the merits, because I would like to start with the merits, I would like to make a general introductory remark and present the parties, if you allow me. The introductory and general remark is that the Slovak Republic's strategy is quite clear. It would like to portray itself as the good. Belmont, I would say, the bad, and EuroGas is the very ugly. We, Belmont, do not know or do not no longer know what EuroGas is. We don't think it is relevant for us. What is certain and what we would make clear is that Belmont is the good, and as we will demonstrate, the Slovak Republic, the bad and the very ugly. The case, in summary, that we will be putting to you during this opening statement is extremely simple. I think you have a lot of documents on the record, a little bit less in front of you, but in total there may be 10, 15 documents that may be relevant material for decision-making purposes as far as the merits and Belmont's jurisdiction is concerned. The case is simple, and I would say scientifically a strong case where we can only prevail. Why? On the merits, the Slovak Republic snatched our investment by applying a law retroactively, and moreover, in any event, in violation of the authorization given by the Slovak Republic that we be able to mine was a fresh authorization until the end of 2006. And that authorization was confirmed later by site visit, that in reference to that authorization, that they confirmed that the works were progressing and in good standing. And then the Supreme Court of the Slovak Republic confirmed that the taking was in violation of law for all the reasons I just mentioned. It was retroactive, the spirit of the law, moreover, was not applied, there was a fresh authorization that was not respected. Procedurally also it's flawed. Why? Because we were not given due process. No heads up at all even. Worst, the decision, as we know again scientifically, was taken by the Slovak Republic, which even published the tender before notifying us of it. And here again we're blessed with a Supreme Court decision that found in our favor on procedure as well. They said the procedure for the taking of their rights was procedurally flawed. We had no right to be heard. And there was no compensation. So how good does it get? And there are aggravating factors that we don't need, which are corrupt practices. Corrupt practices. We know, thanks to the documents that we underwent the burden of obtaining. I'm not talking to the document that about the document that you did not allow on the record, but others that I'll walk you through, that shows that there were third-party investors in contact with the ministry, and that whole procedure was not transparent. And although you didn't admit that document we relied on, the reference to our brief was in relation to that specific email that described that there were wrongdoings, contacts during the tender process. Then procedurally, during that process, was also tainted and constitutes aggravating factor. Why? Because we were told, had expectations with the Supreme Court decisions of 2008. It came back to the mining office. It gave it to another company. We won again in 2011, the Supreme Court on substance. They send it back to the mining. They said, no, we're not going to give it back to them, to another company. And then when we wrote and engaged with the Slovak Republic, it told us it's premature. I'll walk you through the letter. The procedure is still pending. And then once we got out of the hamster wheel by going back and forth around, we asked for compensation and said this time we're going to arbitration. They said, and I'll walk you through the correspondence, no, quantify it, quantify it, quantify it, quantify it. I'll walk you through 5, 6 letters. They said, no, quantify it. And we found out we were taken for another ride, because they used the whole process. They knew the date, the triggering date by which we would say we stopped the negotiations. They launched the criminal proceedings, not because of any wrongdoing with EuroGas, but on the allegation that since we were claiming so much money, necessarily there was such fraud, and they snatched our documents. They returned it, but they kept it. So in other words, they have all of our documents, including privileged documents, and we don't have their documents. And when you order production, we begged for production, an order for production, you gave that order, they did not comply with that order. We managed to find some documents, we put them on the record, The other we mentioned, but we didn't have authorization to put. So it is crystal clear that the respondent did not comply with the production order, and that excuse that we deleted the documents, it's archived. How can it be archived? Archived, the procedure was pending before the Supreme Court. And there was a corruption case filed locally, so they cannot. It was deleted by the government official engaged in corrupt practices, but that's not called classified. And it was classified. There would be letters, there would be explanation as to the practice of the governments. Then finally, when we get to this arbitration, we are faced with what we call frivolous defenses. I will explain why. I will let Ms. Burton address EuroGas's jurisdictional objections. They sound to Belmont as if the Slovak Republic, however, is more Catholic than the Pope. It knows better than the creditors what's good for them. It knows better than the trustee what's the interest of public law. It knows better than the judge what's Utah law should be. It knows better that form should prevail over substance. But that's EuroGas' story. As far as Belmont is concerned, the true jurisdictional defenses do not stand under law. They do not stand under law. Rationa temporis, we have Supreme Court decisions. Moreover, Supreme Court decisions that were in our favor, but they were not respected by another act of state. Then Supreme Court decision, in our favor, not respected by an act of state. We have the conduct of the respondent that says it's premature, wrote to us to confirm, as per his previous letter, that was premature, and is now raising this defense. And on the Belmont side, it is just citing in bits and pieces these letters. It does not stand for the many reasons I will advance to you. And again, it is inconsistent with its own position on EuroGas. Just pause 1 second. The conditions precedent for the closure of the sale purchase agreement of 2001 allowed closing only on July 18th, 2001, when the Securities Exchange Commission, the Ventures Canadian Commission, authorized the sale. Yet on July 11th, it's scientific, it's on the record, it's being put to you repeatedly that EuroGas was a dissolved company. So it cannot have any capacity to conclude that agreement. On the date of the closure, it was a dissolved company. Now, there are 5, 6 other reasons where their argument doesn't stand, but this one, on which they heavily rely against EuroGas, again, is inconsistent with the position that they take, that not only closure was completed, which was not, because all the documents refer to deals to be completed, and moreover, it could not be completed because at the outset, the company EuroGas was dissolved. Now, who are the parties in this arbitration before I go to the merits? Yes, we have the Slovak Republic and Belmont. EuroGas will present itself. Belmont has been around since 1978, 40 years. It's listed in the Venture Canadian Stock Exchange, as well as the Frankfurt Stock Exchange. It has never been dissolved, never been bankrupt. It's led by professionals on the business and engineering front. It is doing very well if you look at the current market in terms of stock, and they have secured recently a huge project in Nevada. That is Belmont. Who is the Slovak Republic? The Slovak Republic, here again, my learned colleague very eloquently during the last conference call and today, between the lines, says, well, we're a sovereign state, victim of wrongdoers, and we're obliged, as it said last time, to defend with taxpayers' money. Well, all this sounds good in provincial dinners. I'm in Nice. Oh, my friends are impressed. Oh, it's a sovereign. Oh, it represents a sovereign state. You have to be serious. In investment arbitration, it is what it is, and we will see what that is. Let's look at what a Slovak Republic is. I propose that to walk you through this document to not to badmouth respondents in the limited time we have, but because it is relevant to establish a pattern, a damning pattern of conduct in relation to tenders and foreign investments that was exactly implemented as far as we are concerned. Now let us turn to that. If you kindly turn to tab 1 of your binder 1, and you should have a sticker in there. It says, it's a corruption report, EU corruption report, and the tab page says, many accept corruption, Slovakia, as part of their daily life, 35%. Then if you look at the next tab, it's a a World Bank report of 2000. If you go to the where the page where there's a sticker, it says the surveys reveal the corruption is common and affects all sectors of economy. Then if we move 10 years later, more recently in 2012, by way of example, it's a tab 3, article from 2012, corruption hurting Slovak economy, secret services say. So it's the Slovak secret services that acknowledge that corruption is a common practice in, if you read public tenders, and the version of the European funds damaged Slovakia's economy last year, the Slovak counterintelligence service, SIS, said on Thursday, then says identified manipulation of public infrastructure tenders, and down says tens of thousands of Slovaks took the streets in February over leaked transcripts of meetings of senior state officials in which they allegedly discussed kickbacks in return for the sale of public companies. You go to the next tab, you would see a U.S. Department report 2013 that says non-transparent, ineffective legal systems, and refers to corruption, and the following page 3 says lack of transparency in public tenders ranks among the areas of most concern to foreign investors. Political pressure on regulators in several offices has at times resulted in changes of leadership to influence the outcome in specific regulatory educations. And finally, the next tab, November 9, 2010, tab 5, says EU cash tunnel ends in Slovakia. It gives a large number of examples of irregularities, of corrupt practices in relation to public tenders. The most telling one is a tender which one of the ministries put on a hallway of the ministry, but that hallway, moreover, was closed to the public, and it was $100 million plus. So that is the Slovak Republic. This is the damning evidence of its practice. Corrupt, 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 as acknowledged by the government himself, the secret services, and the taxpayers' money. You see from this article, it's not me talking, it's not my client, it's EU's money, basically it's your money and it's my money. So the whole story of cliches of a sovereign state, victim of wrongdoings and taxpayers' money is consistent with the track record, and more importantly, with the specificities and the facts in this case. And I will propose to walk you through these facts and discuss the merits by walking you through the chronology, through the damning chronology, through the scientifically damning chronology, through the key documents, starting with our investment. Now, Belmont invested in the largest talc deposit in Europe, and again, these are not our words, but the words of the Slovak Republic, including after the revocation of our rights. If you look at tab 6, you will see that statement concerning the quality and volume of estimated reserves. The deposit at Jamerska ranges among the largest European talc deposit, and it provides all the data that in fact it is Rosman, including during the shareholding of my client, that obtained and which is being used by the government. Now, by way of background, in 1992, a respondent granted Dorfner to gather information and samples on the deposit for testing, to revisit the old data that was available based on outdated technology, and to carry out additional drilling. Dorfner undertook with another company called OSTU a technical evaluation in 1994 and completed a feasibility study that you would find in tab 7. You don't need to look at it, it's just out there for you to have a complete chronology. Then what happened is that on May 7th, 1997, the company Roseman was incorporated. Dorfner held 32.5% shares in it, OSTU 24.5%, and Rima Morin 43%. Now, who is Rima Morin? You've heard that it was a shareholder from the outset. It was also a shareholder during the Belmont, when Belmont came in. It held the dual hat of a contractor. There was a litigation with this company and its dual hat, and the company exited ultimately, as I will remind you later on. It is, more importantly, owned by a gentleman called Mr. Courage. Who is Mr. Courage? He is the one that actively facilitated, took part in the corrupt practices that led to the revocation of our rights, and also is the beneficiary of the revocation of our rights, because Mr. Courage's wife, who is an accountant, formed a shell company called Intelligence or something that won the tender when it was snatched from us, the deposit, in the conditions that I described. And it is Mr. Courage who, beneficiary of the taking, in collusion with the Republic of Slovakia, who has been offered by Slovakia to provide testimonial services in this arbitration. Now, what happened? I continue with the chronology. On May 14th, 1997, the District Mining Authority, and you have it at tab 8, issued Roseman a general mining authorization for an indefinite period of time. In 1997, the District Mining Office, DMO, issued the certificate for the transfer to Roseman of the exclusive mining rights. That you have at tab 9. Then, if you move at tab 10, you would see that the Ministry of Environment of the Slovak Republic granted in 1997 to Roseman the exclusive right to perform geological work in order to search for talc deposit. Another date that is relevant is on February 24th, 2000. You have it at tab 11. That's when Belmont, February 24th, 2000, acquired 57% interest in Roseman for $1,500,000 approximately, and you have the substantiation to that at tab 11 by buying shares 24.5% from OSTU, 32.5% from Dorfner. And what happened during the Belmont area, 2 reports were issued. The first was commissioned and issued, it was commissioned by Roseman and issued in April 2000, so after the Belmont's shareholding. It's a free model of the extraction area produced by a company called Kloidhofer, which increased the proven and expected results of the talc. If you look at that kindly, you have it at tab 12. And at page 16, you would see that it identified 850,000 cubic meters of mineralized rock located in rich sections containing at least 60% of talc, which translated in over 1.4 million tons of pure talc. That is relevant, 55% more than those estimated in the feasibility study. You would see in italics at 3. On the other hand, feasibility study, the assumption was made that there is only 920 million tons of extractable talc reserves. It also confirmed that that is a minimum talc content. This means that the talc reserve is even greater still. Under the Belmont era, May 29th, 2000, a final report of a German state-accredited testing agency called ARB ECV was issued. You have it at tab 13. It concluded that 77% of the end product would be of a high-grade end product with a talc content of at least 98%, and identified the most effective way to process the raw product in order to maximize quality. In the meantime, it is in our memorials. I'm not going to walk you through them, but there is a truckload of permits and authorizations that were obtained by Roseman to begin opening the deposit. Most importantly, if you turn at tab 14, is an authorization of the mining activities dated May 29th, 1998, valid until December 31st, 2002. Okay? So having everything in hand, Rosmint, which had recently obtained final reports increasing the level of confidence in the reserves, identifying the most effective means to proceed, had obtained permits, authorizations to proceed, and organized the tender so as for the opening of the works. Who won that tender? It is the one and only Rima Morin, represented by Mr. Korech. At the time, he was a shareholder. He held 43%. So he took on two hats, one as a shareholder, one as a contractor. Works, if you look at tab 15, a monthly report dated October 18th, 2000, started effectively on September 25th, 2000. So here we are, permits, authorizations, good reports, and a contract, and works began. We ran into a problem. Now, we would see as a post facto defense in this arbitration, respondents saying, oh, this company, Roseman, they were not going anywhere, they didn't have the budget, they were not paying Rima Morin. Well, that is irrelevant because it's post facto, okay? And in any event, superseded by the authorizations, the new contract that we signed that I'll walk you through. But if we even stop there, you would see that it's not true. It's not because Roseman had financial difficulties that the project stopped. The fact is, and this is recorded, it is because Rima Morin and its shareholders were having serious disputes on shareholding issues and on the quality of the works, including as well as the fact that the works were going over budget that Rima Morin had identified and pursuant to which it had secured the works. If you look at tab 16, you would see that the adverse positions taken by Rima Morin without any warning against the position of all other shareholders in Roseman was acted in a document, C348, letter from EuroGas to Rima Morin. It said, at the shareholder meeting, Mr. Robo attended as a representative of the majority shareholder of your company. You opposed in your capacity as a representative of the company, Rima Morin, several of the motions filed as recorded in the minutes. Your oppositional attitude greatly surprised us, and the letter goes on and on. If you look at tab 17 then, you would see that there were problems also on the construction front. Driving and reinforcing were not performed in accordance with the project documentation. Alternation of the driving of the gate in the incline was implemented without any submitted and approved project documentation. So also there were significant construction issues with that company. Rima Morin and respondent says, oh, because this was for financial difficulties. That shows that it's not. Shareholders' problems, construction works, and there was no financial difficulty. Roseman was paying Rima Morin. If you look at tab 18, in a letter that remained unanswered and is not addressed, you would see on on the last page that it is tab 18, it is Exhibit R169. It says it is clear, Roseman writes, from the table above that all the payments have been made. And in fact, an extra advance payment has been received. And that letter was not challenged, and it corresponds to the reality. And in fact, if you turn to tab 20, or tab, sorry, 19,